Good morning and welcome to the Committee of Adjustment hearings for Panel 3. We are City of Ottawa quasi-judicial tribunal that holds public hearings to consider Planning Act applications, including minor variances to the zoning requirements and consent to sever land. Our hearings are now in person at Ben Franklin Place, 101 Centrepoint Drive. We also enable remote participation by video conferencing for our registered speakers. We are live streaming on YouTube, and the video will be archived and available for future viewing by the public. My name is Terry Otto. I'll be chairing today's hearings, and you can address me by my name or as chair. And with me are my fellow panel members, Martin Vervoort, Jocelyn Chandler, Beth Henderson, and Gary Duncan is on remote. The procedure for the hearings will be as follows. Listed on the agenda and appearing on the screen from time to time are the applications we'll hear today. For the sake of efficiency, I may deal with agenda items in a different order. Panel members have reviewed the planning reports and any written submissions in support or in opposition to the applications. Today, we'll hear any oral submissions relating to the applications. As part of the statutory public notification requirements, each applicant was required to post a sign on the property in question before the hearing. They also had to confirm in writing that they did so, or they'll need to swear an oath or affirm an oath today that they fulfilled the sign posting requirements. Otherwise, we may have to adjourn or postpone the hearing. The panel may ask for a brief presentation of an application followed by questions for the applicant and city planning staff. We'll then hear from members of the public who have registered to speak. We may also have questions for them. Finally, the applicant, who has the burden of proof, will have the opportunity to make final comments in reply. Please address your comments to me as the chair, starting with your name and spelling if necessary. All presentations are limited to 5 minutes. Any exceptions will be at my discretion. At the end of the hearing, the panel may either make an oral decision or we may reserve our decision, which means it won't be delivered today. In either case, and within 10 days, the Committee of Adjustment will send the official written decisions and reasons for it to all the parties, participants, and anyone else who has requested a copy. Does anyone have any questions about the procedure we'll be following today? Fine. We have several applications to hear today, but first we need to deal with some preliminary and procedural matters. Are there any declarations of interest? Ms. Chandler?
Panel 2, address 1319 Johnson, that's minor variance A00220.
Thank you very much. No one else? There are no minutes to confirm. So first of all, we will deal with adjournments. The committee has received a request to adjourn, which means to postpone to a different day the hearing for several items. We have 4 that are on the list. The first one is 4393 York's Corners Road. And I believe the person is remote, Mr. Campbell.
Mr. Chair, we're bringing him in now. It's someone named Jamie.
Thank you.
Hi, good morning. Yeah, we were hoping to adjourn to a later date. Mr. Campbell is unfortunately had some unforeseen health problems and is currently in hospital. So we would just like to adjourn to a later date, have a bit of time to gather everything with him and rediscuss them.
Very good. Do you have a date in mind?
Nothing of particular. Whenever, I guess, your next, what would be your next hearing that would be available for us to meet at?
Well, I'd like to hear from planning first before that may make that decision. The next hearing
For
will
sure.
be 2 weeks from now, but I don't think you'll have enough time to accomplish what you need to do. So
Okay.
I would like to hear from planning.
I think 2 weeks will be too short. Maybe adjourn to the December hearing.
That would be December 2nd then?
I believe you're going to need a variance, which will probably take more than the 4 weeks to apply. So planning has recommended actually adjourning it sine die.
Yeah, I think they need more time to address the minor variance. Maybe pick a time that works for the applicant the best to address their minor variance.
Okay, seeing as how Mr. Campbell is unavailable, can you make that decision or should we do it sine die?
We can just postpone, I guess, would into the new year be better then? What would be the next dates available there then?
Mr. Chair, sorry to interrupt,
Yeah.
but committee staff would recommend adjournment sine die for this file. It needs a full recirculation and we're possibly adding a variance application that hasn't been filed yet. The timeline is to be determined.
Okay,
Okay, perfect.
so you agree with that then?
Sure, we will go ahead on that.
Okay, panel members, you're in favor of adjourning? Sine die? Very good. This will be adjourned sine die. Now, could you stay on the line, please? Because
Of course.
I'd like to call up 3404 York's Corners Road, which Mr. Campbell also was representing. That's also on the list for an adjournment. Do you agree with the adjournment?
Yes, if possible.
And do you have a date in mind? 'Cause
I believe,
I think you're going to have to do some serious discussion with planning before it goes much further.
okay, well, I don't, if you guys could guide maybe as to what you would recommend, and we'll go with that
Planning?
for time-wise, yeah.
So there are two applications associated with this address. One we're recommending refusal, and another one is addressing this conservation authority comments regarding the septic system. It depending on the engineers for the septic system. So I would recommend the adjourn sine die until we make further decisions.
Okay,
That's okay with you? The
sure,
applicant?
let's do that. Yeah,
Very good. Panel members?
I'm not sure
Martin?
that this one needs to be adjourned sine die. Because it'll have to be recirculated again. There'll be a cost to the applicant. So I'm just wondering if we bump it out to January, that would give them time to address the septic issue on the one lot or the one proposed lot that doesn't have an issue, and would give them time to also discuss the other lot that may not be permitted. Those are just my thoughts on it.
Okay,
okay, let's do that, yeah.
very good. So we'll adjourn it to the meeting in January, which would be
That would be January 13th.
Perfect.
13th. Panel members in favor of that? Thank you for your comments, Mr. Verwoerd.
Thank you. Yes.
Okay, that is adjourned till January the 13th. Thank you very much. The next item up for adjournment is 1622 Beckett's Creek.
Good morning, Mr. Chair.
Good morning.
Yes, my name is Ryan Polton with Novatech. With me today is Devin Rajala, also with Novatech. We're the agents for the applicant.
Thank you very much. Do you agree with the adjournment request or?
Yes, the applications do need to be adjourned. We recently revised one of the two severance applications, so I understand that revision needs to be reflected in the public notice. As well, we did receive the city's staff report as well as comments from the Rideau Valley Conservation Authority requesting an adjournment. And so we would request that these applications be adjourned to the January 13th hearing. And just for an explanation, the comments relate to the requirement for a geotechnical report with regard to slope stability. And this adjournment will give us time to prepare that report and coordinate with city staff as well as Conservation Authority staff.
Very good. So you're suggesting the date of
January 13th.
January 13th. Planning, have you got any comments in regards to that?
No, we agree with the adjournment and the dates.
Panel members?
I just want to confirm with staff that they have enough time to recirculate.
Committee staff would prefer sine die. The cost is the same to the applicant, whether we adjourn for recirculation to a fixed date or say sine die. That way, the ball is in the applicant's court to how fast they can get those revised documents into us.
Ms. Chandler?
Given the content regarding the geotechnical concerns, well, I know that geotechnical reports can be prepared in a fairly short period of time. You may find the review period a little bit more extended than you would expect from the CAs, given the situation with the provincial government guidelines right now. A sine die might give you the time you need to get through that.
I understand that. My instructions today are to request an adjournment to January 13th. I do appreciate that there will be a period of review once the report is complete. My understanding is we expect the report to be complete within 4 to 6 weeks. If it's 6 weeks, that gives us a month, so approximately mid-January to mid-December to mid-January, to be able to have that review period with both the city staff and Conservation Authority staff.
Okay. So in favor of adjourning till the 13th of January? Panel members? Very good. You're adjourned till the 13th of January. Thank you very much.
Thank you.
And just to confirm, Mr. Chair, if that's for recirculation, we'll need to follow up with committee staff for those procedures.
Understood. Thank you.
Thank you.
Thank you. And the last one we have is 105, 111 Northridge.
Mr. Chair, it doesn't appear that the applicant is online, but they have requested sine die, so we can go ahead in their absence.
In that case, I guess I don't need to hear from planning. Are you in favor of sine die?
I'm not a planner who worked on the application. I'm
Okay.
sorry.
All right. Well, we'll make the decision. Anybody opposed to doing this sine die? All in favor? Thank you very much. It's adjourned sine die. Thank you very much. Okay, that are before us today. We will first deal now again with unopposed applications, of which we have 2. They are straightforward, recommended for quick approval if there are no objections. In that case, I would like to call item number 4, 3455 River Road. Do we have anybody?
Sorry about that, Mr. Chair. No, nobody for these items.
Okay,
Mr. Chair.
then I have to read into the record. There was a slight typo error in the notice that was sent out. The severed land does have 15.24 meters of frontage. That's a correction that has to be read into the record. Very good. Are there any concerns in relation to item number 4? 3455 River Road. If not, in favor of item number 4 is passed. Thank you very much. The next item is number 8 on the agenda. That item is 2772 Harbinson. Again, this is an item that has been put forward for quick approval. Are there any questions, concerns in relation to this application? If not, in favor of passing? Very good, thank you. Item number 8 is confirmed and approved. The next item on the agenda is item number 1. 743 Meadow Ridge. T. White and G. White.
Mr.
Yep.
Chair, we have the applicant.
I am here.
Lisa Boyd online.
Thank you very
Yes.
much.
Sorry, my name's wrong. It's Taylor White. Lisa Boyd is not my name, but I'm here.
Thank you, Taylor. Would you like to make a brief presentation?
Yeah, I would just like to say good morning, Chair and committee members. Thank you. My wife and I are the homeowners at 743 Meadowridge Circle. We built this backyard pergola structure believing that it was within our permitted scope. Once that we learned the overhang was a few inches too close to our property line, we immediately took steps to correct the issue and applied for this minor variance. Sitting planning staff has reviewed our application and confirmed that it does meet all 4 tests under the Planning Act. We've also committed to installing eaves troughs so that no roof runoff crosses the property line. The structure has been well received by all of our neighbors and adds to the character of the area. With these mitigations, we believe that this variance is both minor and in keeping with the intent of the zoning bylaw. Thank you for your time and consideration.
Thank you. Planning?
We have no comments, and please ask any questions if you have.
Thank you very much. We do have a person registered to speak in opposition to this item, Mr. Ron Miner. Would you like to come up, sir? Just push the button on your, there you go.
Thank you. My name is Ron Miner. I'm the owner of 741 Meadowridge Circle. This is my wife, Patricia. And we do have some concerns regarding the application. If I could just read them to you.
Yes, go ahead, please.
Thank you, sir. As homeowner at 741 Meadowridge Circle, we are the most affected by the minor variance at 743 Meadowridge Circle. The structure, or as the owner calls it, pavilion, is part of a major renovation undertaken at 743 Meadowridge Circle during the summer months of 25. The installation of an in-ground pool followed by extensive interlock and oversized structure which affects my property is in fact cutting off sunlight to half of my backyard as shown in pictures, especially in the morning, and it interferes with my views from my kitchen window and living room window. We have been complimented how beautiful the gardens are and how very nice the addition of the neighborhood. Many neighbors and real estate agents have told us so. We are now deprived of privacy, sunlight, and views. We are the only neighbors that are affected by the height and size of the structure, which is an unpermitted oversized structure that is much too close to my fence. No other structure this size in the neighborhood, except for the one that is in the city of Ottawa Park down our street. The height and size of the structure, pavilion, and placement has been built too close to the fence. In Ottawa, there's a criteria to be followed in section 45(1) of the Ontario Planning Act, and it is used to evaluate an application for minor variance and consists of 4 tests that include light, privacy, drainage, and streetscape. In regards to the definition of a pavilion, as the homeowner calls it, a pavilion is a structure used as a shelter in a park or a large garden or place of recreation. In CARP, as part of the City of Ottawa, accessory structures like pavilions are subject to zoning bylaws and limit the amount of lot that can be covered. The zoning regulations are designed to prevent excessive lot coverage by buildings. There are zoning and lot coverage rules in the city. Pavilions are considered accessory structures. Bylaws often place additional restrictions on these, such as where they can be located on a property. Accessory structures must be set back a minimum distance from all properties. A building permit is required for any structure over 108 square feet, according to an email received by Jody Smith from the City of Ottawa Bylaw Services. There was no permit issued for the construction of the pavilion structure. My question is, was there a permit for the in-ground pool? And is there one? If there is one, did it show another ancillary building structure such as a pavilion? larger than the allowable 108 square feet. Would it have been approved with the pool and pavilion? In the owner's opening application for the minor variance, the owner mentioned that he relied on his contractors for the permits to be obtained. Ultimately, it was the responsibility of the homeowner to ensure all permits are obtained and posted, and he should have been aware of the plans and placements. When I spoke to the contractor that was building the structure regarding my concerns about the size and closeness to the fence, the contractor replied, Taylor said it was all good, although in the opening letter, the owner admits the structure was built too close to the property line. If this is the case, then how can a general intent of the bylaw be maintained? This property at 743 Meadowridge is currently for sale and should pass the 4 tests regarding subsection 45 and the City of Ottawa bylaws. It is very unfortunate that as a homeowner in the City of Ottawa, we have now been affected by the oversized structure that was built far too close to the property when bylaws are in place. The owner is admitting that the structure was indeed built too close to the fence. However, we do not feel this is a minor variance. Therefore, respectfully request that this variance be denied and the structure be built in accordance with regulations within the City of Ottawa or removed. Thank you for your time.
Thank you for your presentation. Any questions, panelists?
Just a question for planning. So just to be clear, so the only, I guess, only issue with the structure is the fact that it's, I think, about 37 centimeters too close to the property line. Is that correct?
That is correct.
Okay, thank you.
Yes.
This is, the question is for planning. So the height is fine and the area is fine.
That is correct. For a V1 zone, accessory use height should be, the maximum height, I believe, is 4.5 meters, and the current proposed structure is 3.6 meters. And for the size, it is 55 square meters or 50% of the rear yard, based on the current zoning bylaw. And the proposed structure is about 18 square meters.
Thank you.
Any other questions? Justin?
I have 2 questions. The first is for the applicant. There was a question with respect to a permit for the pool. Now, I don't believe there are pool permit requirements. What is the situation with permits required for your backyard? Like, are you just in the point right now where you're applying for a retroactive building permit for the structure and you have all the other regulatory requirements in place?
Yes, yeah, exactly. So I have my building permit is already in. I got stamped engineered drawings for my entire for the pavilion structure. And I actually just yesterday was talking to city staff regarding my approved grading plan. Yeah, and I have, obviously, my contractor, we have a pool permit, ESA came out, they did all their stuff, like the whole backyard is in compliance. It was just, once we found out about this issue, obviously we had to do everything to correct that. So that's where we're at.
Okay, so my other question is for Mr. Minor.
Yes.
How do you see anything changing with respect to your concerns if the structure was moved 32 centimeters further away from your fence?
I believe it should be more than 32 centimeters.
We can't do that, though. The only thing they need, the only uncomplying thing, so they're allowed the height, they're allowed the size. Sorry,
Yes.
37 centimeters. The only thing they need an exception for is 37 centimeters.
But they are measuring from the post, and I was told by bylaw it was supposed to be from the overhang of the roof.
It's measured from the overhang. The setback is actually measured from the overhang because that's the closest point to the proposed property line. So yeah, you guys are correct in saying that the only thing would be this building moving 30 centimeters, which wouldn't change what they're saying as well.
So back to my question, the entire structure would move 37 centimeters further away from your fence line.
Perfect.
But how do you feel that would resolve your, like, how does that affect sunlight, privacy and views, your concerns.
It does, it still would affect my privacy and sunlight immensely. And I'm also concerned about the drainage. From the whole backyard is hardscape.
There's an approved grading plan from my backyard.
That's
I've been talking to city staff.
That's fine.
Understood,
That
but
was
we
my
are
concern.
only able to deal with the setback from the side yard. The rest is through building code services.
Okay.
Thank you.
This question is for the applicant. One of the comments was that you were going to place eaves trough
Yes.
on for drainage. So is the 37 centimeters inclusive of the eaves trough that you are intending on putting?
Well, the 37 centimeters would be if I move the structure. I'm hoping to not move the structure because it would require, tens of thousands of dollars because this thing's on a poor foundation. But it does not include the eaves troughing. But I could design it in a way that I don't encroach anymore on my setback.
All right, any further questions? I believe we should reserve this decision. Favorite, okay. Thank you very much for your will.
Can I have a closing? Speak?
If you wish, yes, make it short, please.
Yeah. Okay, to determine a minor variance, you need to ask yourself if it has an unacceptable impact on a neighborhood property or community base or factors such as light, privacy, views, spacing, openness, and drainage. A neighbor who builds a large unpermitted pavilion too close to the property lines is sending a message of disregard for local bylaws and lack of consideration for the impacts on the adjacent properties. Being in the construction field, he had applied for a permit. If he had applied for a permit, he would have been aware of the specific setbacks and permits required. For example, a variance might be considered not minor if it results in significant impacts on the neighboring properties related to lots of sunlight, potential for negative drainage issues, negative effects on the streetscape character and the character of the neighborhood. This may be tempting to avoid time, expense, and potential conditions associated with a permit inspection. If this variance gets the okay, the city may be opening a can of worms, as other neighbors may want to do the same thing and install large pavilions in their backyards. And I feel the place for the pavilion is in a park or large area. Thank you, sir, and committee and all the members.
Thanks very much for
Thank
your
you, sir.
input. And you'll receive written notification of our decision later.
Thank you.
Thank you.
Thank you.
Okay, now I've sort of lost my position. Where are we going here now? I believe number 7, 4587 Sarsfield.
Hello.
Good morning.
Good morning, Chair and committee members.
Could you identify yourself, please?
Yes, my name is Teresa O'Neill, and I'm a land use planner with Dillon Consulting on behalf of the landowners of 4587.
Thank you very much. Would you like to make a small presentation or?
Yes, please. And I believe committee has a copy of my presentation slides. I guess question for Devette if she'd be posting them or putting them up on the. Perfect. Okay, thank you. My name is Teresa O'Neill, as I noted, land use planner with Dillon Consulting, and today I'm here as the agent on behalf of Robert Roston and Ingrid Zendorfer, who are the owners of 4587 Sarsfield Road. And I'll be providing an overview of the severance of land and will be available for questions from committee as needed. Next slide, please. The subject site is located on the east side of Sarsfield Road, south of Meadowridge Road, and is municipally addressed as 4587 Sarsfield Road. The subject site is approximately 14 hectares in total. The site is within the rural transect and is designated as rural countryside in the city's official plan. As well, it's also identified within the Natural Heritage System core area overlay and is partially within the Natural Heritage Features overlay. The subject site is zoned rural countryside zone in the city's zoning bylaw. And the application before committee today is for the severance of these lands for the purpose of creating 2 new parcels along Sarsfield Road and retaining a 3rd parcel, which would contain the existing dwelling on the site. And the 2 new parcels are intended for future development of a single detached dwelling on each lot. Next slide, please. All right, the figure on this slide shows a close-up of the 2 new parcels proposed, outlined in pink and lime green. Proposed severed lands A, which are the northernmost new parcel proposed, have an area of approximately 1 hectare with about 87 meters of frontage on Sarsfield Road. Proposed severed lands B, which are adjacent on the south side of that first lot, have an area of approximately 1 hectare with about 84 meters of frontage on Sarsfield Road. Both proposed parcels are currently vacant of any buildings or structures. A conceptual layout showing single detached dwellings and the associated services are shown on the proposed lots to demonstrate that future development is achievable, and the location and setbacks of these conceptual residential development envelopes were recommended through an environmental impact statement to avoid as much as possible the natural heritage features present on the subject site. And we'd like to specify that development on these new parcels is not currently proposed as part of this severance application. Jumping to the proposed retained lands, they have an area of approximately 12 hectares and would have frontage of about 78 meters on Sarsfield Road. These lands currently contain the existing residential dwelling and the associated residential driveway, and no new development is contemplated for the proposed retained lands as part of this application. Overall, this severance application does not require a zoning bylaw amendment or a minor variance to obtain relief from any deficiencies as it meets the standards of the city's zoning bylaw. Next slide. All right, in closing, we wanted to provide an overview of the application before committee today. Consultation between the City of Ottawa and Dillon began in May of 2022 for the proposed severance. And as part of a complete application, the city required an environmental impact statement be completed. The EIS was prepared and demonstrates that negative impacts to the surrounding heritage features can be avoided or minimized by implementing the outlined mitigation, restoration, and management measures. And this report was submitted to the city with this application for review. As well, the proposed severance complies with the minimum distance separation formula as confirmed through the MDS calculations report that was prepared and submitted to the city as part of this application. Lastly, the land use of the retained lands and severed parcels for single detached dwellings complies with the policies in the city's official plan and as well with the standards of the current City of Ottawa zoning bylaw, plus the draft version of the city's new zoning bylaw. Ultimately, the proposed severance seeks to retain both the existing uses and characteristics of the subject area. And last slide, please. Excellent. Thank you, and I am available for any questions.
Thank you very much for your presentation. I guess this could have been green, except we have one person that's a registered speaker in opposition, I believe, to it. But are you in favor of all the conditions that are requested?
Yes, absolutely. We've had a great working relationship with staff, and we've chatted through them. chatted through the conditions with staff, and we agree with the conditions. So thank you, City of Ottawa.
Thank you, Teresa. Planning, do you have any comments?
No, I have no comments.
Very good, thank you. We do have a registered speaker, I guess, Mr. Greg Kenny. Is he online or in person? Very good.
Morning, Mr. Chair.
Good morning.
Members, thank you for this opportunity. My wife Cindy and I, we have the property that's directly adjacent to the north side. That's where we live. But we also have two properties that are behind this applicant's property. And one of those properties, could we bring up that picture, please, to bit? So this is a picture I took yesterday on Sarsfield Road. And this would be approximately, yeah, I just stepped it off, but I have a pretty step about 12 meters south of my property bar, which is just north of the applicant's property. So this would be right where the proposed severance A would be. And this is a historical right-of-way that runs through that area. There's a culvert there. There's two metal posts that used to have a wooden gate, but that wooden gate is gone. Cindy and I have been on, like at our property since 1989. This right of way has been there longer than that for sure, like much longer than that. So this, there's no problem with the severance B application, the second property, but for severance A, we have a documented right of way in our deed. And it was confirmed by my lawyer to the applicants that runs right through that property, like basically right where the proposed residence would be on that property. So I don't know if you can do a partial grant for like the severance B, but I'm willing to negotiate with my neighbor, like to find a resolution, but we can't ignore the fact that there's a right of way that goes through that property right now. The information from my lawyer was forwarded to the applicant, and he said he forwarded it to the consulting company. And that was back probably, I have it documented here, but that's probably like in the spring. And then I never heard anything since. And then just luckily I was going down the road on Saturday and I saw the sign because our road's been closed since May, so no one heads south anymore. The bridge is being repaired. So the sign is like at least 150 meters south of here. And we were never contacted. The 60-meter, I think, we're supposed to be in the area. No notice was given to us. No notice was given to our neighbor across the road. So, but anyway, the issue is there is a legal right of way through that property.
Thank you for your input. Planning, have you got any comments on that?
So staff have completed a title search for the two properties, which is the one that's subject to application and the one that's owned by the member of the public and the two landlocked parcel at the back. We don't see an easement registered on title for the land.
It's not on the PIN, and they've asked for a PIN adjustment. Sorry if I interrupted there, but they've asked for a PIN adjustment. But I have deeds that show it back to 1894, and my deed for us buying the property references this deed, CU 2229. So whatever's on here, it's all described. The right of way is described on these historic deeds. I mean, maybe there was a bit of a clerical error when the PIN was created, but there is documentation of the right of way and historical documentation, like historical evidence, which is very strange that is nowhere on the application that there's a culvert there. All the other culverts are noted, but not that culvert. And there's even, I mean, it's not too significant, but there's even a ditch beside that culvert, like running on this property that's not noted on the application.
Questions? Okay. Go ahead.
This question is for the applicant. What you're using the term right of way. Is it an access easement that or is it a city right of way?
It's a right of way to a property that we own behind.
So it's an easement.
Yeah, and in their application, like in this document, it's part G, they say there are no easements on this property, but there is an easement on that property. On the
And
applicants.
so you're saying there is an existing easement and your lawyer has the information, but it's not on the pin.
That's right, but she, my lawyer Susan Galero, has asked for a pin adjustment.
And I'm just wondering, was there a change of hands on the parcels over the course of the years?
I bought the parcel, it was still, I could give you the exact date, but I bought the parcel, still COVID times, probably about 2021.
Okay.
Yeah, I also,
And it was-
we also own an adjacent parcel back there as well.
And it was identified when you purchased the lands that there was an existing easement?
To be honest, that's the whole reason I bought this land, because I have another landlocked parcel back there. And another reason is it's a family, it used to be all my family. It was my great uncle Dennis Shea's land. So when an opportunity came up to buy those two parcels, like one was 20 years ago, and then this one with the right of way was somewhere around 2021. I have the deed here with the dates if you want that. And when I first, then when Robert and Ingrid moved in, I met with them and I showed them the documentation and showed them that we met at that culvert, just to show that there was an existing, all back through, like through their land, there's an existing really, really nice right of way. It hasn't been maintained at the very front.
Except for there's a culvert and
the culvert, like at the culvert, that's on city property, so it wasn't too grown up, but behind that, it hasn't been maintained for a while.
Okay, thank you.
Thank you.
Chandler?
Two questions. Has your legal documentation been provided to the committee? Like, do we have a copy of this?
Through you, Mr. Chair, no, I don't believe we have anything from Mr. Kelly.
Kenny, but
Kenny,
that's
sorry.
okay, no problem. Both Irish, but I forwarded this in an email. Like again, I can provide proof to Robert, and then I forward the letter from my lawyer. So he had scans of both the my deed that references the previous deed. Well, so now it's a PIN, but references the previous deed that has it described.
Okay, it's just a little bit difficult for us to consider something that we don't have documentation in front of us. Can you
Yeah.
provide that to the committee?
Sure.
Please? Preferably if you have it digitally, like,
Yeah, I can get
Now.
it scanned. Yeah.
well, the problem is you want us to, we're considering this application now.
Okay.
So if you're able to find a way to, can
Through
it,
you, Mr. Chair, I mean, given that it is new evidence, an adjournment might be necessary, even just 2 weeks.
That's what I'm thinking.
I'm wondering that as well, but, I'll let you, then ask the applicant, because that was my next question.
Just a question for Mr. Kenny,
Mhm.
initially. Are your parcels landlocked if you don't have this right away?
They would be, yeah.
It would be landlocked?
Yeah.
Okay. And just a question for Ms. O'Neill. Were you aware of this situation? And I guess what's your position with respect to this issue?
Yes, thank you. Through you, Mr. Chair, our clients and our team as well have been made well aware of this claim that an easement for right-of-way exists over 4587 Sarsfield Road. And in response, when we were made aware of these claims, the owners, our clients, retained legal counsel from Davies Howe. We forwarded them all the information that Mr. Kenny had forwarded to Rob and Ingrid. The legal counsel at Davies Howe, they investigated all the materials shared with us, as well as they reviewed the parcel register for 4587 Sarsfield Road, as well as the adjacent parcels. And they found that there is no evidence of an easement or right-of-way that exists on title in favor of 4515 or any of those other landlocked parcels. They provided us a written summary, with the legalese of why and how this easement does not have legal status currently. They provide that written summary. We have provided that to planning staff, Wendy and Aaron, and they're aware of this. They've reviewed that legal summary as well. And as Wendy mentioned, the city had also done their own review of titles, and there is no evidence of any easements encumbering 4587 Sarsfield Road. And we're happy to share the written legal summary with committee as well, for them to have a look into the how and why that Davies Howe found.
So presumably these lands would have been in the registry system, and they're probably been converted to qualified land titles. And it's not, it does happen sometimes that when the conversion was done, documents are missed. And I guess that's sort of Mr. Kenny's position, that his lawyer is asking for a pin correction.
Yeah.
His easement should be there, and I guess that's something the land registry office might have to determine. But I'm just wondering, there's a lot of information here, but we don't have any of this information. So it would seem to me that it would make sense that if we can adjourn this for a couple of weeks at least and have the information we need in front of the committee. I'm a bit uncomfortable personally deciding this today without the information that's being referenced.
So Mr. Kenny, would you agree to that? And Ms. O'Neill, would you agree to the adjournment for say 2 weeks or maybe a month to get the information?
Before answering that, I will also add, as part of this application, we did have an Ontario land surveyor also prepare the draft reference plan, and the Ontario land surveyor also, looked through all the historical records in preparation of that draft reference plan, and they also did not identify that there's any sort of right-of-way or easement over 4587 Sarsfield Road.
Mr. Chair.
That has legal status currently.
Thank you. Mr. Kenny, final
I will
word?
provide all documents required.
Yep.
Can I just read like 2 quick sentences so on my deed, no, I guess it's called a pin, well, it's still a deed, but the new one, it says your deed, this is from my lawyer, your deed attached specifically references instrument CU 22229, which is the deed with the right of way, see attached, okay? And then on CU 229, I'm reading right from it. It describes the 9 acres that has the right of way, and then it says also the claim which the first part holds and possesses to a right of way extending from the western boundary of said lot number 17, which is Sarsfield Road, basically, to the northwest angle of said parcel of land, the 9 acres, herein described for the purpose of ingress and egress for any and all purposes lawfully required by him. I don't see how they can say there's no trail of a right away.
If I could just, I think we're going to need this information.
Yeah.
And I think we're going to need somebody who can speak to this, probably from maybe legal or planning, and maybe from your council too, Ms. O'Neill, and maybe from your council too, Mr. Kenny.
Yeah.
We can't decide this, I don't think, on the basis of what we have today, but if we, I don't know if 2 weeks is enough time for people to file everything and arrange everything, but I think we need that, some clarity on that.
Jocelyn?
Okay, there are 2 severance applications here. We could hear the one that's unaffected by this, just as an option. And the second thing is with respect, I am not going to be comfortable approving a severance that establishes the landlocked nature of this other parcel unless there is solid legal opinion brought, and that may, as Mr. Brewer said, your lawyer, sir, the applicant's lawyer, and perhaps city lawyer, because this is a legal matter that needs to be decided, not opinions before us. We don't have that set of.
The only thing I would say too is, if I could, Mr. Chair, through you, we may not want to approve the other one if things have to shift.
Oh, that's true. Yeah.
So, but that's up to the applicant to
So
decide
just to
that.
be clear, I don't really want to see this application back unless you guys have sorted out a solution to this. personally.
I'd like to find a solution. So no problem there.
Ms. O'Neill, back to you. How about a month minimum?
Yes, month minimum should provide enough time.
Just for the record, Mr. Chair, that would be December 9th.
Do we have room on the agenda December the 9th?
Yes, we do.
Okay, very good.
And sorry, through you, Mr. Chair, to confirm, would this be for both proposed severed lands A and severed lands B, or is committee willing to consider severed lands B today, as that is not contested, I believe, by 4515?
No, I think we're feeling very uncomfortable about this process right now. I am, a couple of our fellow panel members have expressed. I think we should deal with both of them at the same time on the 9th. Like we said, if there happens to be a right-of-way issue, you may want to change the design, whatever the case may be. So I think we'll deal with them both at that same time.
Well, thank you.
Thank you. All right, we'll adjourn this till the 9th of, I believe, the 9th of December. Very good. Thank you very much.
Thank you very much.
And we have one more item on the agenda, I believe, item number 8.
Mr. Chair, you've granted that.
We've done it. We're done.
We're done.
All right. Well, if that's the case, we've dealt with all the applications today. We have to make a decision in reserve. Thank you very much for your attention and your participation.